In property law, a real covenant is a contractual promise to do or not do something on land. In construing covenants, courts seek to give effect to the party's intent as expressed by the plain language in the covenant. But what if parties use the terms change and modify in a restrictive covenant amendment clause? Are these terms broad enough to permit a party to later add a new promise to the covenant that imposes new obligations? The Colorado Supreme Court considered this question in Evergreen Highlands Association versus West. Evergreen Highlands Association was a homeowners association for a subdivision in Colorado. Within the subdivision were 63 lots, adjacent roads, and a large park. The park was owned and maintained by Evergreen. There were restrictive covenants concerning the park, but lot owners weren't required to be association members or pay dues to Evergreen. Under Article 13 of the covenants, lot owners could release, change, or modify the restrictions if the modification was approved by 75% of the lot owners. In 1995, at least 75% of lot owners voted to amend the restrictions to add Article 16. Under Article 16, all lot owners had to be members of the association and pay annual dues to Evergreen. Moreover, Evergreen was permitted to impose liens on those properties whose owners failed to pay their annual dues. Subsequently, Robert West, a homeowner in the subdivision, refused to pay his dues, and Evergreen threatened to file a lien against West's property. West then sued Evergreen in state district court for a declaratory judgment that Article 16's amendment was invalid. Evergreen counterclaimed for a declaratory judgment that it had the power to collect dues and sought damages from West for breach of an implied contract. The district court found in favor of Evergreen, concluding that the amendment was valid and binding. West appealed to the Court of Appeals, which reversed, holding that the terms change or modify in Article 13 didn't allow for adding an entirely new restriction. According to the Court of Appeals, this was because any ambiguities in covenant language should be resolved in favor of free and unrestricted use of the property. The Colorado Supreme Court granted cert.